Hey everybody, Jeremy Wechsler here, Principal Attorney at the Law Offices of Jeremy A. Wechsler. It's great to be with you. My focus in being an attorney is on estate planning, elder planning, and probate in Pennsylvania. So today I wanted to spend a few minutes with you to talk about healthcare in the age of coronavirus and the tools that you may need if you don't already have them or they're really outdated or you're thinking about it but don't know where to start. I'm going to tell you a little bit today about what you may need to take care of healthcare decisions, kind of breaking down what a living will is, a healthcare power of attorney, DNR, all of those things. So I hope you find this useful. If you need any assistance with these things, you can give my office a call or go online. The information will be right below this video. So let me break down for you first what some terminology is so we can go over that and speak the same language really. So first of all, a healthcare power of attorney is going to be the tool that you use to designate somebody, hopefully somebody you trust, to take care of your affairs health-wise if you can no longer do it yourself. So if you can't speak for yourself, if you're incapacitated or incompetent, you want to put somebody down that you trust to take care of you and make decisions for you, speak with the doctors, decide which treatments to use, and all of that fun stuff. Now, you want to make sure that, again, you have somebody you trust, but you also have a couple of people. So if you choose, let's say, your spouse or your child that you feel comfortable with, that's great, but you want to make sure you have a couple of backups after them in case they also can't do it. So I usually advise my clients to have at least 3 names, so 1 primary and a couple of backups. I get some questions about whether we can have co-agents, and I try to steer my clients away from that because it gets cumbersome with doctors trying to speak with a couple people, 3 people, whatever it may be. You don't want to have a committee making a decision for you when there's an emergency. So healthcare power of attorney generally will give somebody the power to make treatment decisions for you, make medical decisions, when to do surgery, etc., all kinds of things. So you want to have that. Now, what's the difference with that and a living will? Well, a living will is for end of life only. So in Pennsylvania, a living will is often part of a healthcare power of attorney, but they're technically 2 separate items, okay? But a living will is going to cover just an end stage condition only. End stage condition, is, at least in Pennsylvania, is going to be an irreversible vegetative state, an irreversible coma, or irreversible severe brain damage. So really, when you think about a living will, you're really thinking about the very end, okay? Think of no hope of recovery. So in that circumstance, you're gonna select and discuss what you would or wouldn't want done. So that includes general life support, comfort measures like temporary pain relief, food, hydration on a temporary basis, all of those things. And then, of course, treatment decisions. So do you want CPR? Do you want surgery? Do you want dialysis? Do you want a ventilator? And we're going to talk about that in a bit as it relates to coronavirus. So a living will is going to go through all of those questions with you, and you have to answer, again, just at the end, when a doctor has deemed you to have no hope for recovery, what you wouldn't or would want done. And just to give you a little history, this really came about back around 20 years ago where it became more popular with the Terry Schiavo case where she did not have a living will, and her parents on one hand felt that she would want to go one way and her spouse felt like she would want to go the other way, and there was a legal fight for many years over this before they finally withdrew the life support. It even got so far as President Bush being involved, so it went really high up, and now a lot of folks today have living wills. Just to get back to the terminology, a living will and advance directive mean the same thing. So if you hear that term advance directive, you can think of a living will. And just one more thing with terminology on living wills, it's not the same thing as a last will and testament. So think about, I've got a will. Usually you're talking about a last will and testament where that's for when you die, and that's going to make sure your property goes to who you want it to go to. So a last will and testament for when you die is totally different than a living will. It's too bad we can't have some vastly different terminology there. They sound similar, so it gets confusing. But just to be sure, a living will and an advance directive, those mean the same things, and those are for end stage conditions while you're still living. And again, just to recap, a living will often in Pennsylvania will be part of the healthcare power of attorney. All very exciting. All right, now the next terminology term I want to talk to you about is a DNR. What's a DNR? Well, a DNR is a do not resuscitate order, and this is given by the doctor, it's prescribed by the doctor after speaking with you, the patient, or your power of attorney once you're admitted to the hospital. DNR is often confused with a living will because, again, we're going to cut off a certain treatment. We're only talking about cutting off the ability to do CPR if you can no longer breathe on your own. So you could request a DNR as you go to the hospital. If you can't request it, your power of attorney could do that. So a lot of folks say, I want a DNR. When they come to me, what I'm going to say is, you can have a living will. That's what we're going to do for you. But the DNR would be done at the hospital. The living will get you, very far. Like if you don't want treatment at the end, then you're going to be fine as far as that DNR and making sure everything works out. So again, to recap, a living will, healthcare power of attorney, they're going to really be one document for the most part in Pennsylvania. They don't have to be, but usually they will be. Now, I've had a lot of clients and folks ask me about, well, what about in the age of coronavirus? What are we going to do about our healthcare documents? Do we need to update them? Are there specific provisions for coronavirus, for COVID-19? All really good questions. And there have been some articles recently that we have some attorneys saying, yeah, you definitely need to update your living will because there's a provision about the living wills where we talk about ventilators, that if you say you do not want a ventilator, then if you go in the hospital for coronavirus or COVID-19, that if you need one, you may not get one. I don't agree with that because, again, when you look back and you think about what a living will discusses, it's only for an end-stage condition. No hope of recovery, irreversible coma, irreversible brain disease or brain damage, irreversible vegetative state. So, again, a living will is really limited to that end stage only. And when you go into the hospital, let's say you're diagnosed with COVID-19, arguably, I'm not a doctor, but you're not at the end stage, right? There's treatment, there's some hope, right? A living will is for no hope. So if there's any hope, doctors are automatically, that's their job, they're going to do as much as they can to not only keep you alive, but help you recover. We've seen stories now where folks have been on ventilators for 10, 20, 30 days. I've got a relative now that's on the ventilator for a few weeks now, and they're still trying everything. So, I don't think COVID-19, a diagnosis in and of itself, will reach that point at all close to where we get to the living will. So do I think you need to update it just for that? No. However, creating an estate plan means making or giving yourself peace of mind. And I want you to have peace of mind when you go and you create the estate plan. So if it makes you feel better to have a specific provision maybe dealing with COVID-19 in your healthcare power of attorney, just to say, hey, if I go to the hospital and I'm diagnosed with COVID-19, that I want a ventilator or any other, appropriate measures. So you can certainly do that. It wouldn't hurt to do that at all, but I don't think you have to do it. It's really just a question of what makes you the most comfortable. And I would say that's great. If you want to add that in, certainly by all means, go for it. One thing is that you can't account for complications when it comes to any disease. There could be a number of different complications. You could have other health issues that combine with it. So you don't want to get too specific, because if you try to go down the road of being too specific in any healthcare document, it could become ineffective or confusing. And we don't want to tie the hands of your agent and tie the hands of the doctor. So you want to be careful with how specific you get. I will say that when it comes to healthcare decisions, I find there to be the most apprehension when folks may not trust the people that they have chosen or want to choose or think they should choose as agents. So it's really finding the right person. When you think about it, go with your gut feeling. If it doesn't feel right for the person you're thinking about to be appointed, if you don't think they're the right person, you're not simpatico with them, then don't choose them, okay? Choose somebody that you feel comfortable with. Sometimes we have limited choices, so I totally understand that it could be challenging to find the right person, but definitely take some time if you're not sure to identify somebody. It doesn't have to be in the family, by the way. It could be a friend, a coworker, a former coworker, or anybody that you trust to be an agent. So That's really it as far as healthcare documents go for today, but a couple more points before I leave you. I just want to mention that, again, if you've got an old estate plan, if you've got an old healthcare power of attorney, if you have an old living will, maybe you just have a living will, a one-page living will, but not a healthcare power of attorney, consider getting everything updated. Okay, now's the time to do it. Law offices are now allowed to work with clients and do signings. It's a little more difficult, but we can do it. So take advantage of that. Now's a good time where a lot of folks are at home. Maybe you've got a little more free time to actually do some of this updating. Okay, so if you have a plan, but it's old, let's say it's from 2000, 1995, whatever year it is, you definitely want to look at getting it updated. Now, if you have the healthcare power of attorney and living will, great, but also don't forget the financial power of attorney. That's going to cover incapacity. If again, you can't make decisions for yourself, it's going to cover all non-medical issues. So things like paying bills, paying taxes, dealing with real estate, dealing with anything else non-medically speaking that would need to be dealt with. So make sure you have that as well. It's super important. And then of course, having a last will and testament, everybody needs these documents. All three: healthcare, financial, and a will. So make sure you have all three at least. You may have more, you may have a trust, you may have other estate planning documents, but those three are essential for everybody. Before I came on to do this video today, I was looking at an article and it said that less than a quarter of the population, I always thought it was higher, but less than a quarter of the population in the US has an estate plan at all. So now's the time to do it if you haven't done it already, or if it's outdated, get it looked at again. Hope this was helpful. Again, call me, email me, information is right below if you have any questions, and take care of yourselves. Bye-bye.